The fall session of the Supreme Court kicked off Monday, and it is chock full of big cases. Justice Ruth Bader Ginsburg, she says this term will be, her words, momentous. Now, we're going to be looking at a few of them, of these cases. Plus, we're also going to get into with our panel also the issue of guns, but that's coming up. First, let me bring in our guest, Professor Bill Araiza. He teaches constitutional law at Brooklyn Law School. He's a former clerk for Supreme Court Justice David Souter. Thank you so much for the time. I appreciate it.
Happy to be here.
Let's get to the first one, and that is as it relates to electoral law, focusing on gerrymandering or manipulating district lines for partisan advantage. A federal panel, they have ruled that Wisconsin used a secretive process for drawing maps in 2010, and those districting plans were used to get rid of swing districts as well as create favorable ones for Republicans. Democratic voters, they had challenged the map, saying it's unconstitutional. Now it's in the hands of the High Court, and it could have huge national implications. And to me, I think this is, 1A in terms of the significance. What will, when the court looks at this, kind of create the boundaries for me? Are they just looking at, well, we have to come up with a remedy of a different way that we're going to draw up districts every census, obviously, that you figure it out? Is this about equity? What's right and what's wrong when they look at this?
Sure. So it's clear that either most or perhaps even all of the justices think that there's something problematic about gerrymandering. There's no real dispute about that. The real question for the court is whether there is a standard that the Supreme Court and lower courts going forward can apply to figure out when a set of districts crosses the line for being distasteful but still constitutional to, on the other hand, being so distasteful or so problematic as to become unconstitutional.
So I could show pictures, it looks like I'm showing Venn diagrams
Yes.
or ink blots here, the most perverse districts that are drawn, whether it's to just put all the minority votes in one area or to try and create slivers that will work to preserve a district, whatever the racial makeup of it would be. But they say, it's like pornography. I know what it is when I look at it. If they say this looks wrong, how do they decide what looks right?
That's right, and that's really the $64,000 question, in particular for Justice Kennedy, because there are 4 justices who are on record as saying there is no judicially manageable way of saying what's wrong and what's right, and therefore we shouldn't say anything on the topic. Justice Kennedy in the past has said, I haven't found a standard yet, but I'm not foreclosing the possibility that there might be one. Finally,
let's say they come to the decision that the system's wrong, that this is not fairness. Would they, in ruling in Wisconsin, would that be now not only the law of the land, but would they have to redraw districts everywhere? Or would this be relegated just to Wisconsin?
Well, this ruling would be limited to Wisconsin, but whatever principles come out of the opinion would be applicable across to 50 states, and that could cause a lot of chaos going forward.
Put it politely. All right, next case, whether the government needs a warrant to obtain information from cell phone companies showing customer locations. This involves all of us. Now, the case, this is about a robbery suspect who was convicted after phone records placed him near a string of robberies. An appeal court upheld the conviction, saying the man has no reasonable expectation of privacy in the cell phone era. Lower courts have generally said police don't need warrants to get cell phone locator records, but they're relying on a Supreme Court decision from 38 years ago regarding landline records before people ever had cell phones. So I'm guessing 9 justices have to figure out either what the intent was, in terms of our privacy, and also in the digital age where the line starts and stops.
No, that's absolutely right. What you're referring to is a doctrine called the third-party doctrine,
right,
under which someone has no reasonable expectation of privacy in information that they've willingly disclosed to a third party, for example, your cell phone company. And the theory is if you've disclosed that information, you don't care much about it, you've given away your privacy expectation, and the government can go get it from that third-party provider. In today's world, when we give everything up to third-party providers, our locations, our data, our financial information to banks and to ISPs, that's really a very broad possibility for government intrusion into our most basic information.
Bill, this may or may not surprise our audience. Right now, for the most part, when there's criminal investigations, do the cops need a warrant if they want to say, okay, I want to see where Bill was when he placed a phone call last Tuesday? Do they have to show cause, or can they just go to the phone company and say, turn over his records?
They can just go to the phone company and say, turn over his records, because I have no expectation in privacy of my locational data, because I turned it over to the phone company already. The third-party doctrine says, go for it.
Wow. Okay, next case involving union dues and whether or not people not in the union should still have to pay up. And trust me, this one will impact not just union dues, but politics going forward. The unions say that, yeah, you should have to pay because they benefit from the bargaining done by organized labor. 23 states now, they force all public employees to pay in. But a worker at the Illinois Department of Health is suing to change that. The unions say it would be devastating to them if everyone didn't chip in. And I think people have to put this in historical context. Unions used to represent a third of the workforce nationally. Now we're about 10%, some places even less than that. This would further denote this. It would be surprising from my reading of it that they won't, in fact, fight and forward with the plaintiff here. That says you can't compel people to basically pay as basically a precursor to have a job.
That's right. If I had to guess, I would guess along with you that the union is going to lose this case. 40 years ago, the court tried to draw a line between the kinds of contributions that a dissenter could be forced to make and the kind they couldn't be forced to make. 40 years ago, the court said you wouldn't be forced to make contributions to a union for the union's political activities. For example, its political activities on behalf of a candidate for office. But you could be compelled to provide the union funds that would defray the costs of representing the bargaining unit with the employer. That compromise from 40 years ago is now under challenge at the court. Even those fees that are used to defray collective bargaining expenses on the union's part are now being challenged as violating the First Amendment rights of the dissenter.
I can see an inevitability to this, though. Let's say they say that's fine, and you, me, and Joe are workers. Joe and I join a union, you don't. We're fighting to raise the hourly wages for the job. You don't pay into it. They can't stratify that we're going to get a bump and you're not. This is going to lead to, inequities and all the rest.
That's right. The big argument on the union side is that those compelled exactions from dissenters are absolutely necessary in order to prevent the free rider problem that you just described. Why contribute to a union if you're going to benefit from their collective bargaining activities on your behalf? Why not just free ride?
Speaking of free ride, you have been sticking to time limits here, so we have time for the last one. And this also involves worker rights, but this one has to do whether or not they have the right to file class action lawsuits against their employers. So about 25 million people, they've signed contracts that rule out class action suits. We've talked it a lot on the legal programs we've had here. What it does is it forces workers into arbitration for disputes over pay or other issues one-on-one. Well, a group of workers have sued saying federal law makes contracts like that illegal. And maybe it's not the best case, but I thought of Wells Fargo when I saw this, which was so many people, employees, were pushed out the door at Wells Fargo because either they didn't agree with some of the surreptitious practices coming from corporate, or they didn't make their numbers pushing a surreptitious program. Why each one of them individually has to go before the court instead of saying there's 3,500 of us, I'm making up a number, we all have common problems, we'll have more weight if we bring our case together. Is that what we're talking about here?
Yes. I mean, you essentially stated why employers like to prevent class actions, because the individual employees might not find it worth their while to bring their own individual claims, which might in fact be for relatively small amounts. Now, in this particular case, the workers are being backed up by the National Labor Relations Act, which explicitly protects what's called concerted action. For example, engaging in a union or going out on strike, or in this case, bringing a class action lawsuit. That, on the other side, is being opposed by another statute, the Federal Arbitration Act, which expresses a very strong presumption in favor of allowing arbitration agreements and contracts. Very strong presumption in favor, on the one hand, in the arbitration statute, a protection for concerted action, on the other hand, in the NLRA, and that's the basic dispute that the court is being asked to remedy.
This is our first, we'll get our first real idea here of who Neil Gorsuch is. I think it would be a huge surprise if he wasn't basically voting across the board with the conservative bloc of the court. But Kennedy, once again, will be leaving his mark. Do you have any sense one way or the other? Do you think when we're all said and done, we look back at this term, it's going to be one with seismic implications with, for the most part, conservative rulings?
Seismic implications for sure. Conservative side only really, I think, depends on the gerrymandering case. And I think Kennedy's a real wild card on that.
All right, stay with me here because a big issue, obviously, this week, the tragedy that unfolded out in Las Vegas. Now, forget the politics of gun control. Battle rages on in Washington. We'll get to that in future shows. What we want to do tonight is take a look at the law, what's legal, and how the High Court has ruled on the Second Amendment, and if there's anything the courts can do to maybe stop some of this madness.